We've now got hot air, cold feet, and high stakes. Crisis planning response. Delighted Peter Coles and Paul Freeman from Clyde & Co. are taking us through this one.
Thank you, everyone. I'm glad to see there is nearly a full audience to hear yet more advice in terms of planning, crisis response, but we'll be touching again upon issues of criminal behaviour as well as other issues. So I'll deal with some crisis planning points and Paul will deal with crisis response. Can you just see? Hopefully you will all agree that 2018 was a bad year for business aviation in the context of catastrophic losses. And 2019 does not look any better, and we're only halfway through the year. In the slides here, I've given 8 photographs, 8 accidents. Apologies to the manufacturers who manufactured the aircraft in these accidents, but that doesn't suggest that it's a manufacturing issue. In fact, a recurrent theme through 2017, 18 and 19 is a lot of these accidents have been caused by pilot error, and connected with that there have been a number of accidents involving breach of pilot warranties where the pilots involved were frankly not qualified to fly the aircraft concerned, so they shouldn't have been there in the first place. Now, obviously the consequences of catastrophic losses are far-reaching. To deal with some of the normal ones, complex injuries, an inability to work, perhaps forever. You might have been the major breadwinner. Family's now got a very significant problem. The liabilities, civil, criminal, administrative, these can all be far-reaching. So from a criminal perspective, take that first, it is the default position that there will be a criminal investigation into any aircraft accident, pretty much anywhere in the world now. We take Hong Kong as an example. The first people who will attend the site, if the accident happens in Hong Kong, is the Security Bureau. What's their first analysis? It is has there been a terrorist event? Second analysis, is there some other form of criminal behaviour? And if they believe that it is, then that's going to impact the rest of the investigation. And this is also true of many other countries in this region as well as globally. In criminal investigations, they might result in prosecutions. It might be of an individual, it might be of the corporation itself. But when you look at individuals, there's often a perception in this part of the world, although not in North America, not in Europe, but in this part of the world, there's a perception that senior managers, directors, non-exec directors are immune from criminal prosecution. I'm afraid that just is not the case. So don't assume that it's only going to apply to your pilots and your engineers and ground personnel. It will very much be directed at you in senior management. There are all the civil liabilities that might arise, and as we all know, compensation for families, net worth individuals and the like can be very, very high. Paul can probably comment more on that in his section. If you've been convicted of a criminal offence and you are a director or a senior person in high office, then in many jurisdictions the judge, the sitting judge in that criminal prosecution can immediately disbar you from office. Usually it's for about 7 or 8 years, but it can be for life. And if you then hold a position in public office in later life in your court, that's another criminal offence. So you can be prosecuted again. Now I would say that before you buy an aircraft, before you own it, before you manage it, you need to think about crisis planning. It obviously pays to understand the full range of exposures, because if you don't understand the exposures, then you are planning to fail. Very often companies will go to specialist consultancy organisations to look at their emergency response plans. They could be DVI specialists like Kenyans and Blake, some of you may know, may have retainers with. They may be other organisations. But our view as lawyers is that you shouldn't leave these exclusively to external consultants or indeed your own contingency planning departments. They need to be looked at a holistic basis by a number of different entities, because very often they omit very important information. Now, some managers, aircraft managers, will provide customers with information, an information pack or a manual at the beginning of a relationship, and this will cover emergency response procedures and the financial security that is afforded by insurance, and hopefully it also informs them of the gaps, because insurance is not going to cover everything. But very often what we find when we look at these manuals is that there are obvious omissions from them. For example, aircraft management agreements or finance agreements, or some of these manuals will deal with liabilities in the ordinary sense of who should bear the risk of exposures, but what they won't deal with is how you cooperate following an accident. So if you've got a business jet and it's under loan, there's financing behind it, who has actually sat down and decided, well, what's actually going to happen if an accident happens? How are we going to cooperate together? So often that information is actually missing. Now, emergency response manuals, they vary in size, they vary in colours, they vary in multitude of pages. Quite often we see a small operation, something between 7 and 15 aircraft, that has an airline origined emergency response manual. That's of absolutely no use whatsoever to you, because when something happens very quickly, you need to have succinct, easy to read, quick to read information to assist you in that response. Many ERMs assume that an accident will take place at the operator's principal base. They assume that because it's easy to refer to management, to resources, to external third parties that may assist them, but 9 out of 10 accidents happen nowhere near the principal's base, or indeed the country in which the base is in. Many of these manuals don't refer to insurance at all. They don't refer to the insurance broker. They don't refer to the leading underwriter, or if there are more than one insurer, who they may be. These are the people who provide you with financial security when an accident happens, so why wouldn't you refer to them in an emergency response manual? Most of these manuals never refer to external lawyers. Most insurance companies will appoint specific aviation liability lawyers to assist the company in the event of an accident, so it makes sense to put their names and their contact details in them, but very often they don't. And very often they do not contain containment protocols. What are these? Well, these are a series of protocols designed to protect the owner, the operator, the manager from liability exposures. So it needs to be understood right from the beginning, prior to an accident, how the private owner, the company, the high net worth individual, the passengers on the flight, the families if it's a family, the executives, the key account holders, the crew, and the company are to be protected from scrutiny, investigation, interviews, and arrest. There needs to be a policy decision on who will lead the response, who will engage in communications, who will travel to the site, who will manage those who wish to access information. It's common for US corporations to permit or to expect an executive to provide initial comments, but then on advice of the in-house legal team to disappear from the scenes. Whereas in this part of the world, the usual practice is that the president or a CEO not only leads the initial communications, but is there at every press briefing until the claims process until the investigation is over. So what have you advised your executives to do? And this should obviously be in the manual. An often overlooked necessity is to control the flow of information within organisations and invoke what lawyers call legal advice and litigation privilege. These doctrines are designed to enable parties to freely consult lawyers and obtain confidential advice, and to protect communications, documents and records from third parties, including courts. This is needed because in many countries, all information relevant to a claim or dispute must be disclosed, even if you think that information is confidential, commercially sensitive or harmful to your position. Legal advice and litigation privilege can only be invoked in post-accident investigations, communications, reports, etc., if channeled to properly licensed lawyers, and that this is done at the earliest opportunity. Surveyors and adjusters who often appear at the instruction by insurers very early on following an accident, they don't count. Anything that they produce is potentially disclosable to a court of law. Also, not all countries recognise in-house lawyers as having the ability to invoke these doctrines. Critically, it's the laws of the country where proceedings are likely to be brought that determines whether the doctrines are invoked, and it remains open to a court to decide what the purpose was in creating the document. Was it prepared in order to seek legal advice? Was it prepared in contemplation of litigation? Or was it something else? For example, the mandatory internal investigation reports that you do to look into the circumstances of an accident in order to prevent a reoccurrence, they'll only be protected if, right at the moment the investigation starts, it's made clear that you're producing that documentation in order to seek legal advice and to prepare for litigation. But you don't really see that in the beginning of text of an investigation report, do you? It doesn't state that, and therefore there's a difficulty in relying upon privilege to protect that report. Another important consideration are the powers that states have to conduct interviews and to take statements. Your manuals, ideally, I would advise, should contain a list of the type of authorities who may make requests for meetings, what their scope of authority may be, what are the likely purpose of meetings, and the typical questions that might be asked. Now, of course, you can't have a list of all authorities in every country, but if you have a sense of the type of authorities that may be involved in an investigation, what they would normally be, the purpose of having those meetings or entering your premises or taking their documents is for, then that helps in your emergency planning. Now, when evidence or other forms of legal assistance, such as witness statements and service of documents, are needed from a foreign jurisdiction, states will usually attempt to cooperate informally through their respective police agencies, or alternatively, they resort to what is known as formal requests for mutual legal assistance. The legal instruments that they rely upon are treaties, mutual legal assistance treaties. How many of your emergency response manuals refer to these treaties? Do you know what these treaties can do? So, if you take a country or territory, so a jurisdiction like Hong Kong, where the people are out on the streets opposing the extradition bill, these are the types of treaties that I'm talking about. So, what these treaties will facilitate, as example, is examining and identifying people, allowing premises to be entered, allowing documentation to be taken, making persons of interest available for interview, arrest, extraditions and custodial transfers. These can defeat the purpose of exiting a state of occurrence of an accident, in a hurry. That said, there may be reasons to do so given the prosecuting culture of certain states, for example, France, Italy, South Korea, Japan, Brazil, and the list goes on. Of course, following an accident, often the best thing to do is to achieve some sort of compromise and make sure that your executives and your pilots and other members of the crew are not interviewed until there is legal representation at hand. And to give you an example of that, and this is outside the business aviation community, when Asiana had an overrun in Japan a few years ago, the first thing that the pilots did is try and escape the country because they knew about the prosecuting culture there. And the lawyers involved had to go and find them and restrain them and encourage them to participate in interviews but with representation, because the consequences for them and the consequences for the airline would have been profound if they hadn't cooperated with the authorities. Now, finally, we would encourage you to include do's and don't checklists, really simple checklists, in your manuals, your containment protocols and training, because these will then provide rapid guidance on the stakeholders that assist you and how to deal with investigators, the plaintiff bar, and what to say and not to say to the media. Now, before I hand over to Paul, I have an offer for you. So when I step down from this stage, if any aircraft management company comes up to me and says, we'd like you to do a legal gap analysis of our emergency response manual, the first one to come up to me will do that for you free of charge. Paul.
Thank you, Peter. Now I realise you're having a fairly tough afternoon. You've had sanctions. We're talking about crisis planning, now crisis response. You've had 4 lawyers in the space of an hour, so it's been pretty tough going. And here I am now to talk about an aircraft crashing and what happens in the aftermath of that. So a fairly tough gig, if you like, for us to get through. But I think ultimately it is something very important and something that you do need to face up to. The old kind of cliche that you need to prepare for the worst and hope for the best, because if things do go wrong, they really will go wrong in a big way. And if you don't think about them and you take the ostrich approach and you don't do some of the things that Peter's already talked about, then a bad situation is only going to get worse. In this slide, it just gives you an indication of the kind of myriad of the matrix of different players, if you like, different stakeholders who are involved if something does go wrong. At the center of things are you as the operator, owner, management company, all of the above, and you're kind of going to be got at, if you like, from all different directions. Government and investigation agencies, the emergency response authorities and first aiders, and then are going to come into the mix investigators and all the rest. And hopefully in there you'll see in bright yellow Clyde & Co. or some other firm of lawyers, but Clyde & Co. we hope in our self-serving way will be there, not as the bad guys, but there to help you and to help to guide through. And we'll look at some of the aspects of the role and what can happen thereafter. But also very importantly, your broker, your insurance carrier, etc. So a lot of players. And with that mix of players, the first thing to come out, or the most important possibly point from this slide, is that a team approach is critical. Things are bad, something's gone wrong, there's been a crash, some other major incident, and if there is not a team approach, then, as I say, a bad situation is only going to get worse. Things are bad. We're talking about here of some scenario, and there are a number of different fairly traumatic pictures that are kind of strewn, as it were, throughout our presentation, but some bad situations. And if you imagine that's happened to you, then if you don't have that team approach, bad is only going to get much, much worse. So you're really in containment, coordination mode really, to get things in as best shape as you can. And if you don't have that team approach, then it is only going to get harder. Part of that really comes back to what Peter was talking about earlier in his section of the presentation, that you need plans, manuals obviously, training was talked about earlier in one of the slides, and if there hasn't been drills or planning exercises, then think about that. It is only going to get harder if you and the team, your lawyers, your brokers, and everybody else involved who are there to help you, if you guys are only meeting for the first time, then you can just imagine the difficulties of coordination there. So there are a number of functions that flow from that, and I talk about them in the slides. Coordination, obviously, between the different parties that may be involved in the operation of the particular aircraft. The management company, obviously the owners, and all those different parties involved. And as we kind of work through, that we're just going to only in the short time available work through some of the early stages, but if you can imagine the timeline and the chronology unfolding, there's liaison with the various officials and investigation authorities who are going to be rapidly all over the situation, rapidly all over your base, seizing information, seizing records for the aircraft, etc., for the crew. So things are going to be happening very, very quickly, and that possibly, is another key point to take from this. Not only the team approach, but the fact that the time that you have available to get things into as best shape as you can is going to be very, very short. If you think about the rapidity of social media and reporting these days, we've all seen incidents on the news, on CNN and elsewhere, where accidents happen in all parts of the world, and within minutes, literally minutes, there's coverage. So there's not a lot of time to get your thoughts gathered. And liaison and putting into place the plans that hopefully you do have as quickly and as efficiently as possible are very important. Just to pick out another last point from this slide, preservation of information and documentation is critical, because in all of the chaos that inevitably flows from no matter how well a response is planned, there will be chaos. There will be the overlay of emotion and stress. To get things preserved for the future is key. If evidence goes missing, then that is only going to be used against you, even in the most innocent of situations. So the initial response time, if we take T plus 60 minutes, pretty short kind of time frame, what sort of things are you going to be looking for, and what sort of things are going to be happening? Well, you're going to be looking to gather information, confirm what has happened, get as much information together as you possibly can, and start preparing for dealing with, as I say, on the one hand, perhaps the investigation authorities, the emergency responders, but also if we're looking at an accident where people are injured or killed or a mixture, then it's very critical to start looking to have some idea of what's going to be said to those people and to get things in as best shape as possible. But it is, in that early stage, very much an information gathering exercise. Immediate priorities are getting to the scene. As Peter said, I think earlier, it's not necessarily going to happen at your home base. It could be far, far away, and the support mechanism you as an organization may have in that part of the world may be very stretched. So you need to get people to the scene as quickly as possible and start contacting people who are affected. I talked about the speed of response. Social media is all embracing in our modern world. It's unavoidable. And we can't just, as I said earlier, bury our heads in the sand. There has to be a response and, if you like, an embracing of the fact that this is part and parcel of modern life. So think about what you're going to do to respond to that and to manage the situation. It is, as I said on this slide, a matter of owning the message, centralizing information, and making sure that the response that you have in your normal day-to-day website information is appropriate, is sensitive, gives factual information, and is in context of the situation that you face. So that's social media. The rest of media, if I get the right page, here we are moving the time frame forward to perhaps a 3-hour from notification situation. You need to be being ready to give a message to the world, to the media, and it's often a conundrum as to who should be presented as the face of the organization to give that message. Do you shield your senior executives from the press, or do you, in fact, put them full frontal, as it were, to the media and to be the face of your organization and response? I think, there are different approaches, different views on this, but I think ultimately the best is to have the most senior person that you can possibly have available to be the initial front for the company and to give the message that you want to get portrayed. So coming back to the planning point of that, media training is an important thing to bear in mind, and to have a calm, factual, compassionate and emotional response to the situation from the executive that you have facing families, facing media, and facing authorities. Interesting point here. Do you say sorry? In different cultural regions around the world, there are different connotations to how you respond, what condolence messages need to be given, at what time, religious and other sensitivities. Hong Kong has, in the last 2 years, brought in legislation which is interesting, because we lawyers get very nervous when people start issuing apologies, because that, in our kind of way of thinking, connotes an admission of liability. But the legislation that Hong Kong, in a very innovative way, has brought in has basically said that apologies and giving an expression of regret cannot be used as evidence against that organization in terms of liability. So it gives that ability to be able to express that necessary condolence without looking at liability issues. So, just quickly, as I'm conscious of time, other things to bear in mind: assistance for those that are affected, financial, family assistance legislation is quite prevalent around the world these days. Whether it strictly applies to corporate jet and business jet operators is debatable in some countries, but as a matter of best practice, putting these sorts of procedures into place, counselling, financial support, etc., are very important. And just finally, you'll be pleased to know, just to really give you some indication of the real broad multifunction support that lawyers can give in a crisis response. You have providing just an on-the-spot, as it were, legal resource in the post-accident stage, of giving information on liability regimes, on what to do, what to say, etc. And then moving through, basically coordinating with insurers, providing advice to allow risks to be minimized. Also, very importantly, allowing you to get on with your business as best you can. You don't want business to grind to a halt. So giving the support to allow you to be able to continue functioning is important. And then as the timeline unfolds, looking to deal with compensation issues, and that can vary in different parts of the world, and we'll often call upon different lawyers to support us in an overall claims strategy for different places around the world. If things can't be resolved through negotiation, then defending litigation and dealing with all of that. So I'm conscious that's been a fairly rushed kind of approach, but there's a lot of information there, and I think Peter and I are happy to take questions. Thank you very much.